Judge. Sorry.
Okay.
Okay.
Yep. Now we're ready. Thank you, Mr. Doyle.
Yeah. Where's lunch going to be? Is that what that was about?
Wherever you're buying, Jim.
Yeah. Okay. Good one. Here we go. Austin Dean.
Hello.
Good afternoon, Mr. Dean. I'm
Hi.
Judge Hill.
Hi. Nice to meet you.
Nice to meet you. I'm with the Kansas City, Kansas Municipal Court.
Yep.
It looks like, oh, I'm sorry, I have the wrong person's case pulled up, so you don't want me to talk about that
No,
person's
you're
case.
fine. You're fine.
Just give me 1 second. I thought I had brought it up. Okay, it looks like what you have pending are a domestic battery and a criminal damage. These were alleged to have occurred December 27th of 2020 in the area of 1219 North 133rd Terrace. It looks like you would have to post a $1,000 cash bond at this time to get out. Also, if you are convicted of or plead guilty to domestic battery, there is mandatory minimum jail time, supervised probation, mandatory counseling, fines, and it can affect your right to own a weapon. We have appointed an attorney to your case. We're going to give you some time to talk to your attorney. I'm sure your attorney will make an argument on bond after he talks to you. So just leave your headphones on and tell the person that gave you the headphones that you need to go to the virtual breakout room.
Okay.
I got you. It goes on. Breakout room. Understood.
Thank you. Mr. Lilich, did you have an opportunity to speak to your client?
I did, Your Honor. Thanks for that opportunity to speak with Mr. Dean. Your Honor, I do believe after discussing this matter with Mr. Dean, I believe I do have authority on his behalf to proceed with a plea, but I feel obligated to raise a legal issue if you would allow me to do that here on the jail docket about the length of the
Mr.
time.
Lillich,
Yeah.
did you read my email, sir?
Oh, that's right.
Please,
Judge,
please,
I think we've worked out an agreement to resolve this. Thank you for reminding me of that, Ms. Hutton. I got my client's discussion took me off of that track.
Okay,
Judge, I think the city has a motion at this time.
okay.
Your Honor, as I emailed Mr. Lillich shortly before docket started, this case is almost 5.5 years old. One of my officers is off the force. My victim was not terribly cooperative all the way back in 2020. And so at this time, the city would dismiss these cases. I believe that Mr. Austin has already spent several days in jail, and I believe at this time it would just be appropriate to dismiss the charges and move on.
Mr. Dean, I'm going to assume you would have no objection to this case being dismissed.
Listen, I asked the officers, I said, can you get a breathalyzer for these two drunk people that just beat me up and said I did the domestic at the
So
time this happened? You know,
Hey,
You
yeah, it
don't,
was,
you don't want
yeah,
to give me any potential facts.
all right.
What I will say is this is what's called a dismissal without prejudice. That means in theory, the city could refile it. It sounds like though, there may be some sort of a legal issue if it did get refiled.
Yeah.
The city would have to send you notice.
Okay.
Here's the only bad thing. You're the very first person we're seeing on this docket, and we
Yeah.
have to see everyone before we can send over the paperwork because we all have to send it in one batch.
Yeah.
It will get out today. It
All right.
just will be a few hours,
Cool.
unfortunately.
Thank you. Thank you so much.
Okay?
I got a baby on the way. It makes my day. Thank you.
Oh, that's good. Congratulations.
Yep. Thank you.
Thank you.
Yep. Have a good day.
You too.
Sorry to interrupt you, Mr. Lillich. I just didn't
No.
want you to.
Ashley, I'm glad you did. I got off track and got sucked into the discussion, so thank you.
Okay.
Well, back on track. Next door, Landrum or Mayombe. I did confirm he went to high school here, so hopefully we'll be able to move through on Mayombe. He is not an American.
Okay.
Back
Okay.
soon.
All right.
And Mr. Lillich, you saw my note on Mr. Landrum as well, hopefully. It's in the first email I sent.
I'm looking right now. Thanks,
Yes, sir.
Ashley.
No problem.
Pardon me, Judge, Mr. Mayombe is here.
Okay, just give me 1 second. I'm on the phone.
Sure, no problem.
Sorry about that.
No problem. Are we ready?
Yes.
All right, here we go.
And of course, I had guessed wrong, so I have the wrong. Good afternoon, sir. I'm Judge Schultz with the Kansas City, Kansas Municipal Court.
Nice to meet you.
Just give me 1 moment to get your case pulled up. Okay. So it looks like you are being held on city cases. It looks like there are some allegations of trespassing, interference with an officer, lewd and lascivious, battery, and criminal damage. Right now, you would have to post a $1,000 cash bond to get released from jail, and the city is seeking jail time. You have been appointed an attorney. We want you to leave the headphones on and tell the person that gave you the headphones that you need to go to the virtual breakout room so you can speak to your attorney.
Breakout room. Leave them on. Leave them on.
Mr. Lilich, did you have time to speak to your client?
I did, Your Honor. Thanks for that opportunity for me to visit with Mr. Mayambi and review his case. Your Honor, Mr. Mayambi has been a bit indecisive, but I do think I have authority to accept a plea offer from the city on his behalf. Your Honor, before I summarize for you what that plea agreement is, I would just note that I did explain to Mr. Mayambi his rights related to trial and the fact that he would have an opportunity to review discovery with our office and have us assist him with preparing for trial. Your Honor, after that discussion, he's indicated, even though he's wavered about it, he's indicated to me he wishes to accept the city's plea offer. Your Honor, it's his understanding that he would be pleading guilty to interference with an officer, battery, lewd and lascivious exposure, and trespassing, and that in exchange for that plea, the city would move to dismiss criminal damage to property and trespassing, and recommending that that the court order him to serve 10 days in jail, but that he be placed on probation from that 10 days for 6 months on the condition that he have no violent contact with the alleged victim, that he complete an anger management evaluation and a behavioral health evaluation and follow the recommendations, that he not return to 8929 Parallel Parkway or 701 Central Avenue, and that he pay, well, I talked with him about paying a fine of $523.50. I don't know if that 23.50 is appropriate, but Your Honor, I would ask the court to review his trial rights with him again, but my understanding is he's asking that the court adopt that agreement as its order.
Okay. First, sir, I want to make sure that we all have the same understanding of the plea. Is that your understanding of the plea offer, what Mr. Lilich just said?
Yes.
Okay. And I want to make sure that you understand your rights. Do you understand that you do have the right to a trial?
Yes.
Do you understand that at a trial, your attorney would assist you?
Yes.
Do you understand that before a trial started, you would have the opportunity to look at the discovery, such as the police reports, to help you get ready for a trial?
Yes.
Do you understand that the city would have the burden of proof and would have to prove their case beyond a reasonable doubt?
Yes.
Do you understand that your attorney would be able to ask witnesses questions at a trial on your behalf?
No.
You don't understand that your attorney would be able to ask questions?
Yes, I understand.
Okay, so the city would put on evidence, they would call witnesses, and after the city would be done questioning the witness, your attorney would have the opportunity to question that witness. Do you understand that?
Yes.
Okay. Do you understand that you would have a Fifth Amendment right against self-incrimination?
For what?
That the Fifth Amendment right against self-incrimination is that you can choose to testify at a trial or choose to remain silent. Whoever is the fact finder is unable to draw any inference or conclusion from that. The fact finder has to make the decision based on the evidence heard. So if you choose to remain silent, it could not be held against you. Do you understand that?
Yes.
And do you understand if you did go to trial and you were found guilty, you would be able to appeal that decision to the Wyandotte County District Court?
Uh, okay.
Is that a yes?
Sure.
Well, that's not giving me a lot of confidence. So I want to make sure you understand, if you did a trial over here in the city court and you were found guilty, you would have the right to appeal that and ask for a new trial in district court. Do you understand that?
Yes.
Okay. And knowing all of that, are you wanting to accept this plea offer?
Yes.
Okay. So, you said the 10 days was supposed to be underlying, right?
That's my understanding,
Okay,
Your Honor.
okay. So, sir, you will get out today. It will be later today. We have to see everyone first and then send the paperwork over. So it could be a few hours. You will need to return in person to City Hall on Thursday, February 12th at 10 a.m. for a probation check-in. I would suggest that you arrive about 10 or 15 minutes early to make sure that you are in there by 10 a.m. Okay? When you
Where?
get at City Hall, when you get released from jail today, they're
Where?
going to
City
give
Hall,
you
where?
paperwork. They're going to give you paperwork that shows the address of City Hall and tells you when to be there. Okay? All right, we'll see you on Thursday
Thursday night, what time?
at 10 a.m. and that'll be all on the paperwork you get from the jail when you are released.
Get copies of everything when you get released. All done there, Judge?
Yes.
Okay. Landrum, Gary Landrum will be up.
All right. Good afternoon, Mr. Landrum.
Good afternoon.
You have been appointed an attorney on your cases. I'm Judge Schultz. I don't know if you remember me. We spoke maybe a little over a week or so ago. We're going to have you leave the headphones on and tell the person that gave you the headphones that you need to go to the virtual breakout room so you can speak to your attorney, okay?
Okay. She
All
said I
right.
need to go to the Virgin breakout room. Yeah. Yeah. Oh,
I'm sure the judge has said you're going to talk to your public defender.
Ma'am, I'm going to step away for just a minute, but I will be right back.
Sounds good.
Is anyone else struggling with IMDS or am I just lucky today?
I haven't so far, but now
Okay.
I'm worried that you're sending bad juju our way.
I hope not. It just keeps shutting down on me and telling me that I already have an instance open and I'm like, where? So it's fine.
Okay, okay, good. Mr. Lilich, did you have an opportunity to speak with your client?
Yes, Your Honor. Thanks for that opportunity to meet with Mr. Landrum. Your Honor, the city has made a plea offer that I have reviewed with Mr. Landrum, which he's declined at this time. Your Honor, Mr. Landrum has advised me that he has been in the Wyandotte County Jail for 14 days.
January 23rd is when he was booked, is what I show.
Okay.
So I think he's pretty close to right
Okay.
on that.
And Your Honor, what's his present bond amount, please?
$5,000.
All right, thank you. Your Honor, he's advised me that him being incarcerated for 14 days is going to be a reminder that he needs to keep his court dates in the future should the court grant him an own recognizance bond. He acknowledges that he did miss a prior court date. Judge, he has advised me that he has a job as a forklift operator at Amazon. He has two young dependent children. He advises me that he and their mother all live together, but they are dependent upon him for his care. Judge, in light of him having been in jail for 14 days and him being concerned that he's going to lose his job at Amazon, he would ask that the court grant him an OR bond today, set a court date down the road. He intends to schedule an appointment with our office to review discovery thereafter, should you grant him an own recognizance bond.
Ms. Hutton, what is the city's position on bond?
Your Honor, the city would oppose an OR bond. I've never seen this many open DUIs. There are 5 of them. I have new charges that are domestic battery related. There are 22 open cases going all the way back to 2020. I have absolutely no faith that if we let Mr. Landrum out, that he would reappear, or that he would do so within any time frame that would be
I promise I
abused.
will
So,
appear.
Mr. Landrum, wait for the prosecutor to
Oh, I'm
finish.
sorry.
Okay?
Oh, okay. I'm sorry.
so that would be the city's objection, Your Honor.
Okay, and Mr. Landrum, it's
Yes,
my
ma'am.
understanding that you did want to say something.
No, I was saying I'll appear in court. I have my little 10-year-old daughter, and we don't got no family member up here. So my girlfriend, she have to go to work, and I just watching my daughter while she go to work, and she watch while I go to work. And I need my job working at Amazon. I've been there 8 years, and I'm trying to keep that. And if Your Honor, if you can't grant me a OR bond, I'll be thankful if you can just give me a bond reduction.
Okay, so here's what I'm gonna do. I'm not willing to grant you an OR bond at this time. What I will do though is I'm going to reduce this from a $5,000 cash bond to a $500 cash bond. I'm also going to schedule that if you aren't able to get that bond posted, we are going to schedule you to be transported to court next Thursday at 8:30 a.m. Ms. Hutton, I know this is a very tight turnaround, but I'm asking that you make sure that Mr. Lilich's office has all the discovery so that they can review the discovery with Mr. Landrum. And at that time, Mr. Landrum, your attorney can renew the request for an OR bond after you two have had a discussion, okay?
Okay.
Ma'am, if I may, if Mr. Landrum does pay the bond, would you also put into place a restriction that he is not to drive unless properly licensed to do so?
Yes.
I am
So I will
concerned
say
that
it's a $500 cash bond with conditions. You are not to drive unless properly licensed and insured, and you're to have no violent contact with the complaining witness in this case. And Ms. Hutton, you don't happen to have the name, do you?
I apologize, Your Honor. I think I had it in my I think I had it in my let me I do have the name, ma'am. I just need a moment.
Okay.
Actually, I do not have the victim's name. I apologize, Your Honor. I'll need to go through the police report.
Okay, will you just make sure that you send that to Ms. Love so that she can put it on the documentation?
Nakisha Bell. I found it.
Okay,
Apologies.
how do you spell that?
Naquueshabell.
Okay, thank you very much.
And it looks to be that same address that Mr. Landrum is at.
Yes, yeah, so it's a no violent contact, not
Yes,
a
ma'am.
no contact. So that
Okay.
means that if that bond gets posted, you are allowed to go back home, okay?
Okay.
You're
All right,
just
thank you.
not allowed to have any violent contact with Miss Bell.
Okay. All right, thank you, Your Honor.
Okay, so we'll see you February 12th at 8:30 a.m., okay?
Okay. February 12th. Okay.
All right, thank you.
All right, thank you, Your Honor.
All right, Judge, down the hall, Decker and Young. Back
All
soon.
right, thank you.
You bet.
Updated with the victim's name in IMDS, ma'am.
Thank you.
Pardon me, Judge, Mr. Decker's here.
Perfect.
Okay.
Yes. Good afternoon, Mr. Decker.
How you doing, Your Honor?
I'm doing okay. I'm Judge Schultz with Kansas City, Kansas Municipal Court. It looks like you are not actually being held on the city cases. You've already been given an OR bond. There is some sort of a motion pending on your older cases, and then on the new cases, it looks like the city is seeking jail time. We have appointed an attorney to your cases. We're gonna give you some time to speak to your attorney. So if you would leave the headphones on and tell the person that gave you the headphones that you need to go to the virtual breakout room, and Mr. Decker, I want to make sure, it's my understanding that Mr. Decker has a potential release date on his county case of April 1st. So, Mr. Lilich, if this needs to be continued for any reason, let's
Oh,
try
hold
to
on, hold on.
keep that data in mind.
Your Honor. Oh,
Yes,
okay, hold on. Here he is.
yeah,
Oh, you need to go to a virtual breakout room?
yep, perfect,
Sorry.
perfect.
All right, thanks, Judge.
You're welcome.
Miss Kathleen, is Miss Stephanie in her office? Or is she in court?
Let me check for a moment.
Okay. Ooh.
I believe she's in court.
Okay. Thank you, Miss. Thank you, Miss Kathleen.
You're welcome. Would you like me to go get her?
No, Miss Kathleen, not yet. I'm gonna try to do it without her.
Okay.
Okay, Mr. Lilich, did you have an opportunity to speak to your client?
Yes, I did, Your Honor. Thanks for that opportunity to meet with Mr. Decker. He and I have discussed his pending motion to revoke his probation, and we have reviewed a plea offer that the city has made on his new charges. Judge, after reviewing that information with him and going over with him his right to have a hearing on the motion to revoke, and his rights related to trial on the new charges, Mr. Decker has opted to accept a plea and stipulation proposal from the city. Your Honor, it's his understanding that he would be stipulating that he violated the terms of his probation and pleading guilty to failure to appear and fleeing or attempting to elude, and that the city would be dismissing the new charge of possession of drug paraphernalia. It's his understanding that the city will be seeking revocation of his underlying sentence that he was on probation for of 30 days. It's our understanding the city is not opposed to him having credit for time served. Your Honor, on that point, he's advised me he's been in the Wyandotte County Jail since January the 7th. And it's also his understanding that the city would be seeking new fines on the charges he's pleading guilty to of $250. Judge, Mr. Decker would ask that the court adopt those terms I've just described as its order to resolve these matters.
Okay. Ms. Hutton, do you know, it used to state in the ordinance and that failure to appear, I'm looking at it now and it does not state this anymore. Do you know when this changed? It used to state that failure to appear was $50, like flat under
Yes,
the
ma'am.
ordinance. Do you have any idea? It does not say that anymore. It says no person released from custody who has promised or was ordered to appear at a later time before the municipal court shall fail to make such appearance at the designated time. And then even 111 still doesn't state an amount. Do you have any idea when that changed?
No, ma'am, I do not.
Okay.
And Miss Johnson was originally the one to put in the $150 on the failure to appear, ma'am. So I'm not sure what her thought process was.
Well, I mean, it, depending on when it changed, it could be okay.
Yes, ma'am. Well, she made it, she just put this in January 16th, ma'am. So,
I'm just trying to see. Trying to see if I can see the history on this ordinance. Okay.
I think it looks like the last time it was updated was back in 2015, ma'am? Or am I reading that wrong?
Well, I don't know, because now I said compare it to, and then it's now giving me a couple of different versions. Let's see.
Oh, wait, no, that was wrong. I was looking at the wrong thing. It doesn't have a hot link to the changed
I
one.
know, I hate that. Why?
Yeah, how am
Why
I
does it
supposed to
not?
know?
Um,
88? That certainly can't be right.
no, that's not right. Let's see.
Can I see some tissue? Uh, no, I gotta blow my nose. Blow my nose. I get some tissue. A roll of toilet paper.
Okay, let's see. Well, it wasn't then.
Thank you.
So, Ms. Hutton, would you be willing to, just for now, would you be willing to change it to $50 so that, and then I can find out exactly when they took that out? And then, you know,
Yes,
once
ma'am.
I know that, then it would not, if I knew for sure it happened, I'm guessing since the offer was so recent, it probably has not changed since the offer was made, but since I don't know that for sure, I just feel uncomfortable.
Yes, ma'am.
And I'm gonna guess, Mr. Lilich, you and your client would not object to a lower fine.
No, we would not, Your Honor. And I'm trying to follow along with you here online, and
Yes.
I'm not completely keeping up with you, but I do see the failure to appear under section 1-10.
Yeah, and it used to specifically state in the ordinance that violation was a $50 fine. And that sentence is gone.
It has been adjusted in IMDS, ma'am.
Okay, and just because I don't know when,
Understood, ma'am.
I just would rather be cautious than not.
Yes,
Thank
ma'am.
you, Your Honor.
No objection.
Okay, okay. So, now, sir, let's make sure now that I've confused everything, let's
You're
make
on-
sure everything is clear as mud for you. So it's my understanding now that the updated plea offer is that you would enter a guilty plea to one count of fleeing and eluding, which would be $100, and one count of failure to appear, which would be $50, for a total of $150. And the city would dismiss the possession of the drug paraphernalia. Is that your understanding on the plea offer part?
Yes, ma'am. Yes, Your
Okay.
Honor.
Okay. And then, so I know that the other cases show a revocation status, but if you look all the way back to my note when this plea was entered, back in August of 2025, I put a note explaining that he is not on probation because there was no underlying jail term.
Oh, yes, there was, there,
There
yeah.
is no, the terms are not enforceable on the revocation. In fact, I don't even know if Ms. Henson or Ms. Holton even bothered to file a motion to revoke based on my remark back then stating that, hey, like, I understand you wanted
I
to
remember that.
class, but that's not, there's nothing to enforce that.
Yeah.
Your Honor,
Yes,
yes, I was gonna ask for clarification on this because I do not see a revocation and I did see that
Right.
note.
right. So back
Oh, my
when
bad. I'm
we
sorry.
accepted
I
that
didn't mean to. I didn't mean. I just didn't. I was trying to pay it. I'm sorry.
So back when
All right,
we
I got you.
accepted the plea offer on the original case,
My apologies.
there were some terms listed, but they did not list an underlying jail term. And I explained without underlying jail time that he's not on probation and that there is kind of no, so, do the classes, don't do the jail time. That's the carrot, right? The underlying jail time. And then the stick is if you don't do the class, then you have to do the jail time. Well, the offer didn't actually include jail time. So I am just going to close those two cases. And Ms. Holden, it was appropriate that you did not file a motion to revoke, okay? Because he was not on probation. You and Ms. Henson did nothing wrong, okay?
Judge, I
thank
appreciate
you.
that clarification. Just for the court's information, Ms. Hutton and I had a discussion while I was meeting with my client by phone, and we weren't real clear on what the court's order was. But we kind of agreed that it was a 30-day sentence, but it seemed ambiguous. But that was our agreement, but I appreciate the court's clarification.
I don't have an objection, Your Honor. I was, as Mr. Lilich stated, I was also confused by the verbiage. And so I was trying to understand the best of my ability what Mr. Weaver was attempting to do.
Yeah.
And that's what I thought he was attempting to do, ma'am, but I don't, I understand if the court does not believe that he was successful.
Yeah, because when I look at the attorney recommendation from back then, the attorney recommendation stated guilty on trespassing and petty theft, and a battery and a second trespassing were dismissed. And then it says pay restitution as ordered, checkmate, and not to return, but there's no jail term at all listed. So you
It says
can't,
30 days jail paroled, ma'am, which is what
it's
we,
not on the attorney rec.
oh, it was on the one I looked. I apologize, ma'am. Maybe I've got the wrong one.
The one that I'm looking at there, it does not say 30 days jail paroled. It just says pay restitution as ordered, checkmate, not to return to location. And I don't know how to send this to you
Ms.
without.
Hutton, I think the confusion here is we're looking at the plea recommendation that Mr. Weaver entered in on the new charges.
Okay.
And I think we both were off the mark by looking at that. I think that misled us. Judge, I appreciate the court's clarification. So if the city is still good with our agreement, then I think we just need to give Mr. Decker some time to pay on these fines.
City is still good, Your Honor, yes.
Okay, and then Mr. Decker, I just want to make sure that you understand your rights. Do you understand that you have the right to a trial?
Yes, ma'am.
Do you understand that at a trial, your attorney would help you with that?
Yes, Your Honor.
Do you understand that if you did want to go to trial, you would have the opportunity to review the discovery, such as the police reports, to help you get ready for trial?
Yes, Your Honor.
Do you understand that at a trial, the city would have to present evidence and prove its case beyond a reasonable doubt?
Yes, Your Honor.
Do you understand that at a trial, your attorney would be able to ask witnesses questions on your behalf?
Yes, Your Honor.
Do you understand that at a trial, your attorney would be able to present evidence on your behalf?
Yes, Your Honor.
Do you understand that at a trial, you would have a Fifth Amendment right against self-incrimination?
Yes, Your Honor.
Do you understand that if you did go to trial and you were found guilty, you would have the ability to appeal that decision to the Wyandotte County District Court?
Yes, Your Honor.
Okay. And I'm going to put this for a payment review March 23rd at 1 p.m. If you are still in custody on your county cases at that time, Mr. Decker, I anticipate that these will be closed for a lack of ability to pay. When you're in custody, you can't generate an income.
Yeah.
And so those will probably
So,
end up closed at that time, okay?
So Your Honor, if I do end up, which I probably will end up in a bed for in like mirrors or something, can I do? Is this a Zoom?
So if you end up in mirrors, just get a letter from them stating that you were there on that date and bring it to the municipal court clerk's office and they'll work with you.
What, on March 2nd or on March 23rd?
Yeah, if that's where you're at, you don't have to appear, just get that letter once you get out of
Yeah,
mirrors
but
and bring that to the municipal court clerk's office.
okay, but will I have a warrant?
Until they get that letter, yes, but you could also ask, you could sign a release of information with mirrors and have them send a letter in advance saying that you cannot make that court date, and then we can give you a new court date. But
Do
if
I
you
have to
don't
appear in,
sign a release of information with mirrors, they won't send us anything.
do I have to appear in person or can I do a Zoom on that court date?
The only Zoom we do is with the jail.
Oh, really?
Yeah.
Okay, so then can I ask you so I don't get a warrant or don't get anything messing up my drug court and my stuff? Can we just schedule it out until April? Because I'll be for sure I'll be out of mirrors and everything by the end of April, and I could just show up to court.
If you want, we could put this on April 27th at 1 p.m. instead.
Yeah, that would be a lot better for me.
Okay, that's
Thank you,
fine.
Your Honor.
You're welcome.
April 27th
Yes,
at 1 p.m.
yes.
Okay, thank you.
All right, thank you very much.
All right, thank you, Your Honor.
Nico. Yo. Yo.
Good afternoon. Give me
How you
one moment.
how you
Uh,
doing?
I'm doing well. You're Mr. Young, is that correct?
Yes, ma'am.
Okay, I'm Judge Schultz with the Kansas City, Kansas Municipal Court. I just need to finish my note on the last person and then I'll bring up your case, okay?
Okay, what's this traffic court?
I don't know if you have traffic or misdemeanor pending. I'll have to finish my note before I can look at your cases, okay?
Okay.
Okay, and Ms. Love, those ones that showed an H status on Mr. Decker, please close those.
Yes, ma'am.
Thank you.
Welcome.
Okay, Mr. Young, thank you for your patience. It does look like the charges pending against you are traffic in nature. I do
Okay.
see that one of them is failing to or attempting to flee or elude, and the city is seeking jail time on that case. Because of that, you have been appointed an attorney. Mr. Young has already received an OR bond from the city, so he's not being held on the city matters, Mr. Lilich. And I show that his county case is set for February 17th, just for a docket call. So just in case we need to do a new date or something. So Mr. Young, you'll leave the headphones on and tell the person that gave you the headphones that you need to go to the virtual breakout room to speak to your attorney.
Yeah.
Yes, ma'am.
Nice, Judge.
You're welcome.
Talk to your attorney.
Your Honor, I need to step aside for a moment, please.
Thank you for letting me know.
Not good till the judge says it's good.
Okay.
I'm on the phone.
Sounds like you got something.
I apologize for that delay. I received a phone call from the court administrator. Okay, Mr. Lilich, did you have an opportunity to speak to Mr. Young?
I did, Your Honor. Thanks for that opportunity to meet with him. Your Honor, the city has made a plea offer to resolve his pending charges, which I have reviewed with him. Although I did explain to him as an alternative to accepting this plea offer, he does have a right to have a trial on these charges, and I have explained to him his rights related to trial. After having that discussion with him, Judge, he wishes to accept the city's plea offer, and I think we're ready to finalize this. I just need one point of clarification from the prosecutor, but it's his understanding that he would be pleading guilty as charged in the pending charges, that the city would be recommending 5 days concurrent. And I just want to check with Ms. Hutton that if that time can be concurrent with his Wyandotte County District Court time. If so, I do think we have an agreement. And as part of the agreement, the city is seeking that he pay a total of $903.50 in fines and costs. Judge, if Ms. Hutton chimes in and clarifies that he can do this time concurrent with his Wyandotte County case, Mr. Young's request would be that you adopt those terms as your order.
Okay, Ms. Hutton.
City would not have an objection.
Okay, so Mr. Young,
Yes,
is
ma'am.
that your understanding of the plea?
Yes, ma'am.
Okay. Ms. Hutton, will you make sure that it's the 2350, not the 5350?
Yes, ma'am. Whoops, sorry.
So it'll actually be $30 less
Yes,
than
ma'am.
it shows. We'll give her a moment to get that updated. And then I want to make sure that we're all on the same page about your rights, sir. Do you understand that you do have the right to a trial?
Yes, ma'am.
Do you understand that at a trial, your attorney would assist you with that trial?
Yes, ma'am.
Do you understand that before a trial started, you would have the opportunity to review the discovery, such as any police reports, to help you get ready for a trial?
Yes, ma'am.
Do you understand that at a trial, the city would have the burden of proof and would have to prove their case beyond a reasonable doubt?
Yes, ma'am.
Do you understand that at a trial, your attorney would be able to cross-examine or question the city's witnesses on your behalf?
Yes, ma'am.
Do you understand that your attorney would be able to present evidence on your behalf?
Yes, ma'am.
Do you understand that if you did want to go to trial, you would have a Fifth Amendment right against self-incrimination?
Yes, ma'am.
And do you understand that if you did go to trial and you were found guilty, you would be able to appeal that decision to the Wyandotte County District Court?
Yes.
And knowing all of that, are you wanting to waive those rights and accept that plea?
Yes.
Okay.
Yep. Okay. Updated in IMDS, ma'am. Apologies.
Thank you. So, okay, we're gonna continue this to March 10th at 1 p.m. if you're still in custody on your county stuff.
Got you, ma'am.
We'll probably end up waiving the fines and fees for lack of ability to pay. But otherwise, if you've been released on the county stuff, you either need to make a payment or appear in person.
Okay, on March the when?
And at 1 p.m. and that'll be
Okay,
at City Hall. We'll send documentation over to the jail. And if you do get released on your county case, they'll give you a copy of the documentation showing you need to appear at City Hall at 1 p.m. or make a payment. Okay?
yes, ma'am.
All right. Thank you.
You welcome. Y'all have a good day.
You too, sir.
All right.
Good luck to you.
All done here, Judge?
Yes.
All right. Next door, Fortis or Noel?
Okay.
Back soon.
Judge, we're having a problem with Proprio here in the office. I'm going to step
Oh.
away for one moment, but I should be back.
Absolutely. Thank you for letting me know.
Hey, Judge, I'm gonna step away for a moment.
Sounds good.
Okay.
Ms. Holton, are you there?
Yes, I am.
Could we borrow your Proprio for an appointment?
Yes, I hope it works. Earlier it wasn't, but let me see if it'll work, okay?
Okay, thanks. Jacob's on his way to your office to get it if that's okay.
Yes, okay.
Okay, thanks.
I'm back, Judge.
Pardon me, Judge, Mr. Fortis is ready. Thomas Fortis. You'll pop in.
Okay.
And start the conversation. Just stand by.
Mr. Lilich, you already know that with a driver's license and with insurance verification, the city would amend just on this case.
Yes, I do, and I'll make sure to mention that to him. Thanks for the reminder. Mr. Fortis, this is Shane Lulich speaking. Well, our office is appointed to represent you. I'll go over what the prosecutor just mentioned with you here in a moment, okay?
Okay.
But we're waiting for the judge right now.
All right. Is there any way possible of going for time served on this?
Let you and I'll talk
I
about that.
apologize. I had to step away for a moment. Give me 1 second. Good afternoon, Mr. Fordyce, is that correct?
Yes, ma'am.
Okay, I'm Judge Schultz with the Kansas City, Kansas Municipal Court. It looks like on the city cases, which is what we're here about today, you've
ma'am.
already been granted an OR bond. It does look like the city is seeking jail time if you are convicted. We are going to give you some time to speak to your attorney. Mr. Lilich, I show that his county case is set for April 2nd. So please keep that in mind if we're trying to do a continuance or anything. So, sir, leave the headphones on.
Okay.
And the person that gave you the headphones, let him know that you need to go to the virtual breakout room.
I need to go to the virtual breakout room. Okay.
Yeah.
She said it's gonna put you private with your attorney.
Okay.
Okay. Mr. Lilich, did you have an opportunity to speak to your client?
Yes, I did, Judge. Thanks for that opportunity to meet with Mr. Fordyce. Your Honor, the city has made a plea offer to resolve his pending charges before you. I have reviewed that plea offer with him. I have explained to him his rights related to trial. Should he want to proceed to trial on these charges, he's opted in lieu of that to accept the city's plea offer. Your Honor, it's his understanding he'll be pleading guilty to driving while suspended, no proof of insurance, failure to display a license. In exchange for that, the city would be moving to dismiss interference, and the city would be seeking a total amount of $623.50 in fines and costs. Judge, Mr. Fordyce would ask that the court adopt that agreement as its order. I have explained to Mr. Fordyce that this plea would certainly have negative consequences on his driving privileges. I don't believe he has any at this time.
Okay. So, sir, is that your understanding of the plea offer, that the interference with an officer would be dismissed and you would be entering a guilty plea? Give me one moment. To the other charges, driving while suspended, no proof of insurance, and not having your driver's license in your possession.
I would. Yes, Your Honor.
Okay. Ms. Hutton, is the display out of the same incident as the driving while suspended?
Just one moment, ma'am. I apologize. And what was the defendant's last name? I'm sorry.
This is Mr. Fordyce, Thomas Fordyce.
No, no, ma'am. Wait. Yes, ma'am. I apologize. Yes, they are on the same. The driving while suspended and the failure to display.
Okay. Do you think that
Your Honor, the city would
ish?
this city would drop the display of driver's license, Your Honor.
Okay. So we'll give you a moment to update that, and
Updated.
then while she's getting that updated, I just want to make sure, sir, that you understand your rights. Do you understand that you do have the right to a trial?
Yes, ma'am.
Do you understand that if you did choose to do a trial, your attorney would assist you with that trial?
Yes, ma'am.
Do you understand that if you did choose to go to trial, you would have the opportunity to review the discovery, such as any police reports, to help you get ready for that trial?
Yes, Your Honor.
Do you understand that at a trial, the city would have to present evidence and prove its case beyond a reasonable doubt?
Yes, Your Honor.
Do you understand that at a trial, your attorney would be able to question witnesses on your behalf?
Yes, Your Honor.
Do you understand that your attorney would be able to present evidence on your behalf?
Yes, Your Honor.
Do you understand that if you did go to trial and you, I'm sorry, did you understand? Yeah. I'm gonna start that question all over. Do you understand that if you did choose to go to trial, you would have a Fifth Amendment right against self-incrimination?
Yes, Your Honor.
And do you understand that if you did go to trial and you were found guilty, you would have the ability to appeal that decision to the Wyandotte County District Court?
Yes, Your Honor.
Okay, and then so it looks like you would owe a total of $473.50, and the city would be dismissing the interference with an officer and the failure to display your driver's license.
Yes, Your Honor.
Okay. And you are wanting to accept that plea?
Yes, Your Honor.
Okay. I'm going to put this on March 24th for payment. If you're still in custody on your county case, we will probably close these for a lack of ability to pay, because when you're in custody, you can't really generate an income, okay?
Yes, Your Honor.
All right, thank you.
Thank you.
Good luck to you. And Mr. Noel. Well, like your wife and mom.
Good afternoon, sir. I'm Judge Schultz with the
Hello.
Kansas City, Kansas Municipal Court. If you'll just give me one moment, I need to finish my note on the last case, okay?
Okay.
Okay, so it looks like right now, you are being held on county cases and, oh, and, well, maybe
Nah,
not.
yesterday I had court
Did
and
they release you on your county
yeah,
case?
I got
Okay,
probation yesterday on
so
them.
it does
State
look
cases.
like you would have to post a $500 cash bond on the city case. And it looks like the city is seeking jail time. You have been appointed an attorney. I'm gonna guess that your attorney probably wants to speak to you first before making an argument about bond.
Yes, thanks, Your Honor.
Okay, so leave your headphones on, but tell the person that gave you the headphones that you need to go to the virtual breakout room so you can speak to your attorney.
Hey, I need to go to a virtual breakout room real quick.
Mr. Lilich? Did you
Yes, Judge,
Go ahead.
thank you
Sorry.
for that. Thanks. Yeah, you want me to go?
Yes, please.
Thanks for that opportunity to meet with Mr. Noel. Judge, the city has made a plea offer that I did review with Mr. Noel. I did explain to Mr. Noel his rights related to trial. After having that discussion, he's opted to accept the city's plea offer. Judge, it's his understanding he would be pleading guilty to one count of resisting arrest. In exchange for that plea, the city is seeking no jail time and a total fine of $300. Judge, I have explained to Mr. Noel that a conviction to this charge could potentially come back and cause him issues with the criminal history score should there be any future felony sentencing issues. Judge, after having that discussion with him, he would ask that the court accept this plea agreement as its order and give him some time to pay that $300 fine.
Okay. First of all, sir, I want to make sure that you understand your rights. Do you understand that you do have the right to an attorney?
Yes, ma'am.
I'm sorry, I meant, do you understand that you do have the right to a trial?
Yes, ma'am.
Okay, you already have an attorney. Do you understand that if you did choose to go to trial, your attorney would assist you with that trial?
Yes, ma'am.
Do you understand that if you did choose to go to trial, you would have the opportunity to review the discovery, such as any police report, to help you get ready for trial?
Yes, ma'am.
Do you understand that at a trial, the city would have the burden of proof and would have to present evidence and prove their case beyond a reasonable doubt?
Yes, ma'am.
Do you understand that if you did choose to go to a trial, your attorney would be able to ask witnesses questions on your behalf?
Yes, ma'am.
Do you understand that at a trial, your attorney would be able to present evidence on your behalf?
Yes, ma'am.
Do you understand that at a trial, you would have a Fifth Amendment right against self-incrimination?
Yes.
Do you understand that if you did go to trial and you were found guilty, you would be able to appeal that decision to the Wyandotte County District Court?
Yes, ma'am.
And do you understand that that entering a guilty plea to this count of resisting could have an impact on your criminal history in any potential felony case?
Yes, ma'am.
Okay, and knowing all of that, are you wanting to accept the plea?
Yes, I am.
Okay. So you will get out today. You are the second to last person that we're seeing.
Yeah.
So hopefully it won't be too long, but we do see everyone first and then send the paperwork over. So it could be a
Okay.
few hours. You'll get out today and then we'll continue this for a payment March 30th at 1 p.m.
Where do I go to pay it at?
That's you can either pay in person at City Hall or online through Pay It.
Okay.
The paperwork that the jail will give you will tell you that you either need to make a payment by March 30th at 1 or appear in person. If you pay $20 to $49, they'll give you a 2-week extension from that date. If you pay 50 or more, you'll get a 4-week extension, okay?
Okay.
All right, thank you.
Thank you.
Done? Right. Good luck to you. And new floor, new pod, last person, Gudger. Back soon.
Yes, thank you. Mr. Lilich, did they say how the in-person docket went? I know we had a pro tem and he seemed to get out of here fairly quickly, so I'm assuming it went well.
As far as I know, it did, Your Honor.
Okay.
City confirms Miss Johnson came back up around 2:30, ma'am. So
Oh, good. That's good. Much better than the other day. Fantastic.
Pardon me, Judge, Mr. Gudger is ready.
Okay. Good afternoon, Mr. Gudger. I am Judge Schultz with the Kansas City, Kansas Municipal Court.
Okay.
You are not held on the city cases, but since you are in custody on a county case, we decided we would try to see you. The city matters that are pending, the allegations are lewd and lascivious and a trespassing. I can't remember, let's see. It looks like the city is seeking jail time, so you have been appointed an attorney. We're gonna have you leave the headphones on, but tell the person that gave you the headphones that you need to go to the virtual breakout room so you can speak to your attorney.
I already went to court over these things, right?
Give me 1 second and let me double check, because these still don't show, let's see. A show and offer has been made. It looks, I'm trying to see. Let's see, you were in custody on your Wyandotte County case. You've been in custody since August. Let's see, October, you were continued to November. November, you were continued to December and then to January. And then it just said that you were continued to, so I don't see that you've actually resolved these cases. If you think you know exactly when that occurred, when you're talking to your attorney, go ahead and speak to your attorney. The county case I show was set on February 2nd. And you're not, this is a different matter than that case, I believe.
It was all the same.
Okay, Ms. Hutton, are you able to? I don't know if you're able. Let's have you talk to your attorney while Ms. Hutton tries to do some investigation. So, Mr. Lilich, I show he was booked on August 14th. And I show that the allegations of these two occurred August 5th and August 7th. So I don't know when the allegation for his county case was alleged to occur, but we'll see if we can.
I'll see if I can check on that too, Judge. What's his current bond amount on these cases?
City, he's not being held on
Oh,
these
okay,
at all.
okay,
So,
all right.
and I do show that he was released on his county stuff, but he's got a hold from KDOC. So I don't know. And the county case is 25 CR 969. So that might help in trying to figure out what's going on.
Thanks, Judge.
Okay. So, Mr. Gudger, please let the gentleman know that you need to go to the virtual breakout room and we can go from there, okay?
Yeah.
I call the hand signal. We're good with that. Leave those on, so the judge probably
Mr. Lilich, have we found anything out?
I think we did, Your Honor. And I think accordingly the city has modified the plea offer for Mr. Gudger's case. Judge, thanks for that opportunity to meet with Mr. Gudger. I have reviewed an amended plea offer from the city to resolve his pending charges. Judge, I have explained to Mr. Gudger that he does have an absolute right to have a trial on these charges. I've discussed that with him. In lieu of that, he has opted to accept the plea offer from the city. It's his understanding he'd be pleading guilty to one count of trespassing, and in exchange, the city would dismiss the lewd and lascivious exposure charge. The city is seeking a fine only of $150, and that Mr. Gudger promised not to return to 3725 State Avenue. Judge, in discussing that location with him, we believe that to be the McDonald's. They're just to the east of 38th
38th and
and State.
State. Okay.
So he knows not to return to that location. Judge, Mr. Gudger would ask that the court adopt that plea agreement I've just described as its order.
Mr. Gudger, I know there was probably a little bit of back and forth between your attorney and the prosecutor's office. This plea offer that Mr. Lilich just described, is that your understanding of the plea offer?
Yes.
Okay, and do you understand that you do have the right to a trial?
Yes.
Do you understand that your attorney would assist you if you chose to do a trial?
Yes.
Do you understand that at a trial, the city would have to present evidence and prove its case beyond a reasonable doubt?
Yes.
Do you understand that before, if you did choose a trial, before any trial started, you would have the opportunity to review the discovery, such as police reports, to help you get ready for that trial?
Yes.
Do you understand that at a trial, your attorney would be able to question or cross-examine the city's witnesses?
Yes.
Do you understand that at a trial, your attorney would be able to present evidence on your behalf?
Yes.
Do you understand that at a trial, you would have a Fifth Amendment right against self-incrimination?
Yes.
And do you understand that if you did choose to go to trial and you were found guilty, you would be able to appeal that decision to the Wyandotte County District Court?
Yes, I know that now.
Okay, and knowing all of that, are you wanting to waive your rights and accept the plea?
Yes.
Okay, give me one moment. Okay, sir, I am going to continue this for payment. To March 30th at 1 p.m. If you are in the custody of KDOC at that time, you can send a letter to the Kansas City, Kansas Municipal Court asking that the fines be waived for a lack of ability to pay, okay?
Yeah,
So
okay.
if you're at KDOC, please make sure you send a letter and let us know that you're there and that you just want to see if we can waive the fine, okay?
So where do I send that?
You'll mail it to the Kansas City, Kansas Municipal Court, which is at 701 North 7th Street in Kansas City, Kansas 66101. And I'm sure that there probably will be someone at KDOC that could help you with that address if you needed it, okay?
Okay.
All right, thank you.
Thank you.
get you back. All right, Judge, that was it for my list.
Okay, sounds good.
right,
Thank
well-
you.
You bet. Good weekend to everybody.
Yeah,
You
too.
enjoy the Super Bowl, everybody. Have a good
Oh.
weekend.